Tony, I mean, you took the words out of my mouth. I mean, you're my mentor. I mean, come on. So, I'm Andrew Leventhal, and yes, I am a pure and passionate criminal defense attorney. It's all I've ever done in my life as a professional. And so you all know that I was a public defender in the city of LA, and so that's why I have a particular specialty in every little nook and cranny of the courts in LA County. But my practice really is state and federal at this point. I'm associating with what I think is one of the best federal criminal defense attorneys in the country, Mark McBride. And so he's of counsel to my firm, so we now do state and federal. And yes, I've done it all. I've done it all. I've tried pretty much every case imaginable that you can have before a jury. Any offense listed in the vehicle code, any offense listed in the penal code, business and professions codes, there's so much. But today I'm going to do a cross-examination on a Los Angeles Sheriff's Department crime lab expert. And it's really lifted from an actual jury trial that I did back in 2011 in the Pasadena court. And it is a DUI. Now look, I do a lot more than DUIs. I don't hold myself out as a DUI lawyer, but yes, I can blast them. I've tried more than 20 of them in my career. And what I'm going to do here is what people are interested in, right? Because I'm going to literally turn a breath test result in this case that was a .12, that's above the limit, right, which is .08, and I'm going to bring it down to below the legal limit. And what I'm going to do is I'm going to use objectively verifiable information to do that, empirical data. So the way I cross-examine, you'll see, it's all based upon objective facts. So if the witness wants to, right, give me a hard time, it's going to be what's called impeachment city. What does that mean? I'm going to blast you. So there's really no way out the way I cross-examine. If you say yes, you're done. If you say no, it's really, really not okay. And we're going to go down a different path. Now look, I don't just fight. I mean, I love to fight, as you can tell. I'm probably the criminal version of Justin. Criminal defense attorney. Version of Justin. But the reality is that, no, I have a lot of friends in the DA's office over the years, and city attorney's office, and I'm more than capable of playing nice and settling cases and getting rid of things. But what I want to just explain one more thing is that my practice focuses on really 3 phases in this criminal law world, and it's sort of chronological and sequential. So the first phase is before the case is even filed. It's the investigatory phase. I'm sure Grant has a lot of experience doing that. So what is that? It's okay. It's if a police officer or the government wants to make contact with somebody to initiate an investigation that may lead to a criminal filing. I come in and I do what I can, okay, to put the plug on that so a criminal filing does not materialize. The next thing I do chronologically is an actual filed case, right? I defend people in connection with cases in state and federal court, any violation of the law. You don't need to be there's no such thing as a domestic violence specialist or a DUI specialist or a assault specialist. Either you know sentencing, okay, felony sentencing or misdemeanor sentencing, or you don't. And if you know that, then you can do it all. Because the rest is all the same. It's just an elemental analysis. Did the prosecutor prove beyond a reasonable doubt all these elements or components of this offense? So that's a marketing thing. When people say, I'm a sex crimes lawyer, a real criminal defense lawyer can do it all, okay? So I'm going to go ahead and start, but the last thing I just want, before I forget, the last thing I want to talk about is the last phase of my practice, which we refer to it in criminal law as post-conviction relief. So that's undoing things. That consists of writs, appeals, expungements, erasing convictions, motions to terminate probation early. The list is endless. Right now, let me give you an example. There's obviously, if somebody wants to, let's say, work as a home care aide with the elderly, and they can't because of the prior conviction, because the Department of Social Services says nope. I have a couple cases right now in that regard where I'm trying to present the applicant as somebody that needs to be given a chance. Okay, so I do that type of stuff too. But really, largely what I do is I represent people who are suffering and engaging in self-destructive behavior, really. And I try to use the criminal case as a positive. a positive thing, ironically, to turn their life around, okay, and prevent the conviction or prevent something from being damaging long term. And so that's why I'm so passionate about what I do, because that's what 90% of the system is. 90% of the system is people who are really suffering, not really dangerous, bad people. That's the 10%. Murderers, rapists, child molesters. Really, it's few and far between. How do you think the system makes so much money? Off of poor people who are addicted to drugs on Skid Row. I'm just being real about it. So I actually have a Medicare fraud case actually right now, just interestingly enough, where the accusation, it's a 60 Minutes thing, the accusation is that a residential treatment facility went to Skid Row and said, hey, who's got a Medicare card? Pick them up, we'll give you a free meal, sleep, right? Bring them back, and of course, you know, they sleep maybe one night, and then they document these patients for 6 months going through treatment to justify the funds up front. So that's the allegation right now. And I represent a 63-year-old woman, never been in trouble, who decided late in life, to become what's called a substance abuse counselor. And part of that process requires you to do a little externship at a facility. She was getting paid a minimum wage. No kickbacks whatsoever. She had an idea this was going on, but didn't really know for sure, right? So she blew the whistle, and now she's actually being charged.
Wow.
But I've already spoken with an attorney general case, and the reason why these cases are filed, and I usually have the fruit on at the bottom of the tree here, not the big, leader of the facility, is because the prosecutor wants to have leverage. They want to get more information, right? So if they charge you, with their mindset is, well, if I charge you, then maybe she'll cooperate and give us some more information, and maybe we'll give her some type of break. So that's where we're at in that case. With all that said, let me do this little DUI number with the crime lab expert.
Do I need to move or should I?
No, you're good. I usually have what's called like a...
Where are you going to be? I was set up the...
You want me to go in the middle?
No.
All right, I'll come in the middle. So usually in court, you have what's called, it's funny, when I got bar mitzvah, it's called a bima. But no, it's called a podium, but I always refer to it as a bima. So usually I have I prepare my cross-examination, okay, I literally write out every question, because I think that if you want to be clean and have a record where it's real tight, you better be prepared and write every question out. So that's what I do, and I usually have a little podium to lay it on there so I'm not holding a piece of paper so it doesn't look so tacky, but I need to have this as a reference. So I'm going to do it maybe like this.
Do you want the expert on camera as well?
Yes.
Then go closer to her.
Come out the paper.
Can we put her in a witness stand?
Yeah, what should we do?
Put her in a witness stand.
I want to stand.
Or put the expert in a witness stand.
All right, let's do it. So what happens is, I want you to just to orientate everybody. So this is a DUI where somebody is being charged with driving under the influence of alcohol and driving with a blood alcohol level of 0.08 or greater. So the second charge is called the per se categorical charge. It says we don't really care if you were drunk, we don't care how you felt. If you were driving with a blood alcohol level of 0.08 or greater, you're guilty of a misdemeanor. So at this point, what's happened is that the prosecutor has presented pretty much their entire case. They presented the police officer who went through the entire investigation, and then they put on the crime lab experts, basically talking about how my client was way over the limit at the time of driving, even though almost always the breath test comes after the time of driving, right? And the question is were you driving with a blood alcohol level at the time? I drive with 1 or greater. So here we are, we're orientated. Okay. All right. Let's get into act. Good morning.
Good morning,
Now you're a crime lab expert with the Los Angeles County Sheriff's Department, isn't that right?
Yes.
Okay. Now the Sheriff's Department here in LA maintains what's called a blood alcohol manual.
Yes.
So let me go into this manual. So the breath instrument section, I'm on page 3. I'm going to call you Miss Long, just for the record, L-O-N-G. The breath instrument section in this blood alcohol manual is, I'm going to quote now from your manual, is a written description of the procedures used by the LA County Sheriff's Department to conform with the requirements set forth in Title 17 of the California Code of Regulations.
Yes, that's correct.
So Title 17 then, Ms. Long, is the legal framework that sets forth sort of the rules for California laboratories engaged in forensic alcohol analysis, right?
Yes,
So Title 17 thus covers breath alcohol analysis too, right?
yes,
And Title 17 has these rules in place to, among other things, increase the reliability and the accuracy of these breath tests.
yes,
So you, Ms. Long, as a senior criminalist in the Sheriff's Department, you've read the breath testing portion in this LA County Sheriff's Department Crime Lab manual, yeah?
yes, I am.
And I imagine, Ms. Long, that you, as a senior criminalist, rely upon this blood alcohol manual, of course, to effectuate your responsibilities.
Yes, that's correct.
So let me just take a step back. Why I ask that question is because there's an evidence code section, 721. 721 of the California Evidence Code says this. So look, if an expert relies upon particular materials, sorry, if an expert, you see, I moved around. If an expert relies upon particular materials in court, you can cross-examine them on the subject matter of those materials for days. If they don't, you can't do that in a vacuum. It's inadmissible hearsay, generally speaking. So that's why it's so important to get them to admit that they rely upon it so that you can cross on it, because it's fact, it's empirical data, right? You can't say no. Let's resume. So you rely upon this manual to effectuate your responsibilities, correct?
Yes, that's correct.
Now, let's go to page 1551. Do you have your manual before you? Say yes.
Yeah, I do, yes.
Now, the breath testing portion of your manual, Sheriff's Blood Alcohol Manual here in LA, contains a subsection called, quote unquote, expression of analytical results.
Yes, that's correct.
So I'm staying on the same page, and I'm asking you a true or false question, Ms. Long. Are you ready? So this subsection states, quote, breath alcohol concentration shall be converted to an equivalent blood alcohol concentration by a calculation.
True.
Now, this subsection in this manual is citing language in Title 17 of the California Code of Regulations, is it not?
Yes,
Is that code section 1220.4 subsection F?
yes,
And you know that because you're an expert in this, aren't you?
yes, I am.
Now I'm going to ask you another true or false question. The manual states that this breath to blood conversion calculation is, quote, based on the relationship, colon, the amount of alcohol in 2,100 milliliters of alveolar breath is equivalent to the amount of alcohol in 1 milliliter of blood. Does it say that?
Yes, it does.
So this is known as the breath to blood partition ratio, right?
Yes, it
And I'm going to ask you another true or false question, Ms. Long. At the time of this breath test here in this case, strike that. At the time of the breath test, just generally, strike that just as like a litigator term. Just for, I don't really mean that. Get it off the record. I'm going to start again. So, true or false? At the time of the breath test, a person who has consumed alcohol may not have the same amount of alcohol in 2,100 milliliters of their breath as they do in 1 milliliter of their venous blood.
True.
So true or false? Breath to blood ratios can vary considerably among the general population.
True.
So Okay, so here's the thing. So let's assume that she wanted to play, like, you know, and they would try to be dirty, you know what I mean? Okay? And then, of course, they would quit, and then they want me to hire them to testify for me. But that's another story. Okay? So, all right. So here's the thing. I'm really prepared, right? I've cross-examined this witness before because I've done a lot of jury trial. I have the transcript. So this expert actually testified on volume 2, page 431 of the last jury trial that I did with this person. And he says, in response to the very same question, on page 452, it can, quote unquote. So I'm ready. I'm ready for, and that's when I win. They want me, then I go like, yes. Your Honor, I have in my hand a transcript marked as defense A. May I approach for impeachment purposes? Yes, you may, counsel. I look at the jury and we're doing it.
If I were this guy, I'd probably hang my head in shame. I've just been.
Yeah, it's like, just tell the truth. Otherwise, I'm going to get you. All right. Because, now let's just ask the question again to orientate, because of course I talk too much. True or false? Breath of blood partition ratios can vary considerably among the general population.
True.
Okay. Because you would agree that all human beings are different and unique, right?
Well, of course, Mr. Leventhal, yes.
So,
Dude, all right, Joe, you love it. Make it work.
so let's get an example. So, for example, in a recent drinking scenario, a person may have the same amount of alcohol in 1,200, not 21, 1,200 milliliters of breath as they do in 1 milliliter of their blood at the time of the breath test, right?
Yes.
So let's stay with this hypothetical. In this hypothetical, okay, well actually let me do a hypothetical. Right. In this hypothetical, we're going to simultaneously administer. Let me take a step back. In court, they keep me in line. In court, you can actually, excuse me. Yeah, in court, you can actually ask experts hypotheticals. You can say, assume this and assume that and assume this. Now, tell me this. But you can't just ask a hypothetical in a vacuum. The facts in the hypothetical have to be based upon actual facts in the record. Otherwise, you're susceptible to an objection called assuming facts, not in evidence. Prosecutors go, improper hypothetical, but really the proper objection is assuming facts, not in evidence. So here we go.
How are we doing? Like 5 minutes.
All right, we're going to we're almost done. We're going to do the calculations now. We're going to simultaneously administer a breath test and a venous blood test, okay, in this hypothetical. Then we're going to compare the results. So breath test, blood test, compare, okay? So assume at the time of this breath test and this venous blood test that the subject blowing has the same amount of alcohol in 1,200 milliliters of their breath as they do in 1 milliliter of their venous blood. Again, we administer the test at the same time, and then we compare the results. True or false, Ms. Long? Here, the breath test results will be higher than our simultaneous venous blood test.
True. Yes.
So in other words, in this hypothetical, the breath test would overstate the true blood alcohol concentration here.
Well, yes. Yes.
You grab your calculator?
Yes, I do.
Let's break it out. You know what I'm going to do?
I'm calculating, but
Okay.
yeah. None of us here will be able to, like, we're not.
So, there's a calculation. All right, I want to stay with the same facts, but now we're actually going to compare the breath test results with the venous blood test that is taken at the same time of the breath test. Ms. Long, assume further that the breath test, just like in this case, reads 0.12, 0.04 over the legal limit. Are you with me?
Yes.
All right, true or false? A venous blood test taken at the same time as this 0.12 breath test will give us a blood alcohol concentration below 0.07, correct?
Correct. Yes.
I want to stay with the same hypothetical, Ms. Long. Now we have our results and we've compared the two. Do you agree that there is a discrepancy between the breath test results and our simultaneous venous blood test results?
Yes, by these calculations.
Now, will this discrepancy remain even if the breath test is properly functioning?
Yes, it will.
Will this discrepancy remain even if you know exactly what you're doing in connection with this breath test?
Yes, it
Will this discrepancy remain even if the breath test, the machine is properly calibrated?
will. Yes, it will.
That's troubling. In short, if a person who has consumed alcohol takes a venous blood test at the same time as the breath test, and the breath to blood partition ratio is below what the machine assumes, 2100 to 1, and if we compare, okay, the breath and the blood test here, the breath test results will be higher than the corresponding blood test results.
Sadly, yes, that is 100% correct, Mr. Leventhal. Come on, fight it, Johnny. Drop me.
You could, but that's fine. Trust me. We go past five. So true or false? It is possible that my client's breath to blood partition ratio here was below 2100 to 1 at the time she took the breath test, correct?
Yes, true.
It is also possible, especially with recent drinking, that my client's breath to blood partition ratio was 1200 to 1 at the time of the breath test, correct?
Yes.
All right, true or false? You'd have to guess, would you not? You'd have to guess what my client's breath to blood partition ratio was here at the time she took the breath test.
That is true, Mr. Leventhal.
And as a result of having to guess, it is reasonable, is it not, Ms. Long, that my client's true blood alcohol could have been below this 0.12 breath result.
That's reasonable.
Could have reasonably, therefore, been below the legal limit, 0.08, right?
Yes, Mr. Leventhal, that is 100% correct. That was the body blow, guys.
So at this point, I say thank you very much. Nothing further, your witness. So that's it. So anybody has any questions?
Blood, breath,
It sounds like they need to
So,
change
any
the
questions?
calculation.
Will you stand over here so people
blood,
can?
not breath?
Don't come back.
So,
No, I want to go over.
if we're
Yes.
pulled over, should we take blood or breath?
Yeah, that's-
So let's talk about
Urine,
it.
isn't it?
I mean, if you want to talk about it, we'll get into it. I mean, look, every lawyer has a different opinion on this. I'll tell you exactly what I think, but it's just an opinion, okay? There's no, here's what I think, okay? There's different phases in a DUI investigation, okay? There's a part about the driving, okay? So there's a National Highway Traffic and Safety Administration, which basically says it creates like a uniform model standard in the United States for basically local agencies to model their investigations after. And there's cues based upon scientific research, cues, impairment cues in these different phases of a DUI investigation. The first phase is driving. There's 24 cues, and then it's a phase, right? And speeding is not one of them, right? So whatever, you can't control what your driving pattern is. Then you get pulled over, cop says, let me take a look, license, registration, have you had anything to drink? Just be cool and just say, look, I really appreciate what you're trying to do here, and I understand that you're just trying to do your job and that you're trying to keep the road safe. Unfortunately, I don't feel comfortable discussing that with you, but I would love to cooperate with the remainder of your investigation. Something like that. All right, come out, let's do the field sobriety test, and let's take a breath test at the scene. Now, you don't have to take the breath test at the scene, nor do you have to do the field sobriety tests. Okay, why? Because Vehicle Code Section 23612, subsection H says you don't have to do that. And in fact, the police officer shall, okay, tell you that you don't have to take the breath test at the scene. So don't do it, just be nice, okay? So at this point, the police officer has nothing, okay, except maybe your driving pattern, okay? No admission, no breath test, no field sobriety test. But they're gonna arrest you. So if you really know that you're under the limit, you really know it, take the breath test. But it could be inaccurate, but take it if you don't want to get arrested. But if you're like, you know what, I don't care if I get arrested, I want to beat this no matter what, deny it all. Then you get hooked, and then you go to the station house. And then you have to, it's true. And then what happens is that you're given another selection to take breath or blood, a chemical test. Now, if you don't take the chemical test, you'll suffer administrative penalties, the DMP, okay? So you should, you really should. Unless you really should not refuse, okay? Unless you know that you are so far blasting over the limit that you just take that 1 year suspension with the refusal and just go to court and say, what do you got? You got nothing. But forget that. Let's say, okay, it's been like an hour or so. Don't take the blood test, because the breath test, as you can tell, I just blasted it. Okay? The breath test is inherently more inaccurate because it indirectly analyzes blood. Lots of blood, as I established in Title 17, right? Doesn't say breath, there's a conversion. Take the breath test. The blood test is a direct measurement of what's going on inside. That's what I think.
We gotta move on. Quick one?
So what?
You can pee on the
They
top.
have it, but it's with the code section. I think the code section says that it's got to be breath or blood. If neither is available, then you can take urine. You can't just say I want a urine test. That was the '60s. It's not like that.